Ben. We were going to
Hello.
touch base about COVID and its impact on 54 Act proceedings.
Yeah, absolutely. There's obviously a lot going on affecting commercial landlords and tenants at the moment, but I thought it'd be really good to chat over a couple of issues which are cropping up in 1954 Act proceedings, which are ongoing at the moment. One is opposed and the other one is opposed. So let's do two short videos.
Absolutely, why not? So, unopposed, what are you seeing?
Well, what I'm seeing time and again at the moment is questions about whether landlords can satisfy ground F requirements in cases which are already in the pipeline, perhaps where you've got a trial coming up towards the end of this year. What effect is COVID-19 going to have on landlords' prospects of success?
Yeah, good question. I mean, one point which sort of springs to mind relates to the landlord establishing there's a real chance he will bring about that which he intends in time. And as we all know, Ground F says that the landlord has to intend to carry out the works on the termination of the current tenancy. Current tenancy ends in 3 months and 21 days after judgment, and there is then added on the reasonable period before the spade actually has to hit the ground. And in ordinary circumstances, 3 months is usually a safe bet for your reasonable period. And so you're usually looking at about 7 months after judgment for the spade to hit the ground. But in a COVID post-lockdown environment, it might be that the landlord simply can't start the works because of disruption in the construction industry or delays in getting all of the necessary consents in place. Then I suppose on the other hand, the time for commencing the works is still some way off. So it might be that the landlord can manage to start in time. I mean, I don't know, what do you think?
Yeah, I mean, the difficulty is we've got to keep an eye on this. No one has a crystal ball. We don't know what kind of practical consequences there are likely to be caused by this pandemic in the future.
Yeah.
But I can see a couple of legal arguments that a landlord can deploy if there are difficulties. I mean, the first is well, look, the test, we're dealing with objective intention here. The test is always quite a low bar. A landlord just has to show that there's a reasonable prospect that it can carry out the works on time. No more, it's really no more than a real chance of being able to do so. So if there's a bit of doubt, that might not be enough to destroy the landlord's prospects of success, for sure. But there's also a more direct way that the landlord might be able to crack this particular issue, which is to focus on that reasonable period afforded to landlords to put the spade in the ground after the termination of the current tenancy, because that's a flexible concept. It's normally going to be about 3 months, but it could be longer. And if it's not going to flex in response to COVID-19, what is it going to flex in response to?
Well, yeah, quite. Good point. I mean, reasonableness, as you say, test found useful precisely because it prevents undue rigidity, or I think that's what Lord Rogers once said about it. And there's also, what springs to mind when you saying that is that didn't a trial judge in that case that no one's ever heard of called Francis hold that a reasonable period was 12 months post-vacant possession? I mean, I know that that particular issue was remitted back following an appeal on the basis that the judge hadn't given adequate reasons for deciding that it was a 12-month post-VP period. Did that ever get decided, Ben, when it was remitted back?
No, sadly not. That Supreme Court case came up first and changed everything, so it never went back. But I think there was a general acceptance or a general feeling that 12 months was unduly long.
Yeah.
But of course, there weren't COVID-19 issues at play then, so it's all to play for.
Okay, so that's some of the issues that might crop up on objective intention. Another issue is subjective intention, it seems to me. So subjective intention, the landlord has to make a firm and settled decision to proceed with the works. But what about if the effect of this pandemic is to dramatically affect the viability of the works, or economic uncertainty causes the landlord to really doubt whether it's worth proceeding with the project? The landlord's feasibility calculations might show that the value of the developed premises is not going to increase as much as they had anticipated prior to the pandemic, although the cost of the works are going to stay the same or possibly increase if the programme is going to be drawn out by social distancing. I mean, does any of this matter? Can any of this give tenants an edge? I just throw that out there. I suppose taking a step back, however, and thinking about the way that the law might interact with these issues, there is no requirement for the scheme of the works to be commercially profitable. Landlords are entitled to carry out a kamikaze scheme if they want to. If they demonstrate an intention to do that, it's entitled to succeed under Ground F, isn't it?
Yeah, absolutely. Landlords can carry out kamikaze schemes, provided they genuinely do want to do that. But in reality, in the real world, landlords are going to want to act commercially. They're going to want to make a profit. And if what was once a profitable scheme becomes unprofitable, you would ordinarily expect a rational commercial landlord to pull the plug at some point ahead of trial. And if they don't, they can really expect to be cross-examined really very hard about whether they still want to proceed with a now unprofitable scheme and why. And of course, it's open to the courts to disbelieve landlords when they say, I'm going to do these works. And in fact, that was the attempt that was made by the tenant in Francis, not that it quite played out that way in the end. But I can see that, in fact, some tenants might make an application, a late stage application for viability evidence, to try and get stuck into the numbers and really put the pressure on landlords on this particular point.
Okay. I mean, for some reason, I can well imagine you doing that, Ben, when you're acting for a tenant, especially the cross-examination aspect. So we might find that some landlords discontinue their opposition or lose a trial. But I suppose that the likely course, if a landlord is really worried about their prospects of opposing now, for whatever reason, they will be seeking a short redevelopment break in the new lease. So we might see more of that creeping in. So that's kind of landlord's intention, but just, pausing and reflecting on what about tenants' intentions. I mean, it might be that in light of the new environment, the tenant doesn't even want a new lease, especially if they're, a retail business that's in absolute dire straits.
Yeah, absolutely. I mean, COVID-19 is going to in fact affect the whole dynamic as between landlords and tenants and their intentions when it comes to ongoing litigation. I mean, in either case, if there's going to be a discontinuance, there are going to be cost consequences.
Yeah.
And we may find that it's a case of who blinks first, where in fact, neither of them want to go ahead with their previously stated intention. But the tenant will know that in either case, it's going to get statutory compensation if there is a discontinuance, because an application would have been made and then subsequently withdrawn.
Yeah.
So, well, look, lots of interesting things on Ground F. Let's do another short video on unopposed lease renewals next.
Great. Really lovely to see you. Speak soon.
Speak soon.